So, guys, this is a full transcript of the boost and the fight and the confrontation that happened in court between Justice James Omotosho and Mazi Nnamdi Kanu. The Nigerian media houses will not give you this detailed info of what happened in court. They will just summarize and tell you that James Omotosho gave Nnamdi Kanu a deadline of 7th of November to, do his defense and all that. But they will not tell you how Nnamdi Kanu stood up and confronted him and even, listed that more than 13 evidence and proofs and, backed up his claim that he's not going to defend. He's not going to enter his defense in this particular case. That is what I'm going to reveal to you here. Why Nnamdi Kanu listed the reasons and even cited the Supreme Court judgment and the Constitution of the Federal Republic of Nigeria why he's not going to enter his defense. Just sit back, let me explain to you and take you through. Please do well to subscribe and equally click on the notification button and like this particular video if this is your first time of actually coming here. Now let's go straight to the point. Now, at the resumed hearing today, being the 5th of November 2025, Nnamdi Kanu, who was actually appearing in person, requested for a brief 5-minute recess in the judge's chamber, explaining that what he had to disclose might embarrass the judiciary of Nigeria if said in open court. But Justice James Omotosho declined the request, directing that all submissions be made public. There were things Nnamdi Kanu didn't want to say publicly. He wanted to, have a tete-a-tete with Justice James Omotosho, but James Omotosho said, go ahead and make it public. Nnamdi Kanu said, this is embarrassing, and they thought he was joking. Now, let us go ahead and see what Nnamdi Kanu made public and the reason why he said he's not going to actually open up his defense. He said, Mazi Nnamdi Kanu then proceeded to seek to adopt his motion on notice and accompany written address urging the court to grant the relief sought. Nnamdi Kanu went further to confront him and said, Mazi Nnamdi Kanu's address centered on the jurisdictional foundation of the case. His submission was that the entire trial is void ab initio because it rests on a repealed law, namely the Terrorism Prevention Amendment Act of 2013, which ceased to have legal existence following the Terrorism Prevention and Prohibition Act of 2022. Nnamdi Kanu is saying the same thing he has been saying, that the court or the law that the federal government is using to prosecute him or in the name of terrorism has been repealed. It means it is no longer in existence, that it is the Terrorism and Prevention Act of 2013. Meanwhile, that particular law was actually amended in 2022, and the amendment made sure that what the federal government is actually charging him for is not even in the newly amended law. And Nnamdi Kanu is saying that it is a repealed law, and this particular law, he cannot charge me because before you charge someone, you must look at the Constitution and say, look at what the Constitution says and look at the punishment if this particular person is convicted. Nnamdi Kanu told the Justice James Omotosho, since this particular law has been repealed, what law are you now using to charge me? Look at your Constitution. And James Omotosho looked at his Constitution. Even the prosecution team, being the federal government, looked at their Constitution, and they couldn't even say anything. Nnamdi Kanu fired on and went ahead. Nnamdi Kanu argued that jurisdiction is the lifeblood of adjudication, not a procedural formality, citing the Supreme Court in Madukola versus Nkemdelem in 1962, which held that a court is competent only when the case comes before it under a valid and substituting law. When the federal government and Justice James Omotosho were confused, Nnamdi Kanu went ahead to bring a judgment that was given by the Supreme Court, which stated emphatically that only when the case that comes before it is under a valid or substituting law, where the Supreme Court categorically states that a case will only be valid if the case is under a substituting law under the Constitution of the Federal Republic of Nigeria. Nnamdi Kanu went ahead to fire down again. Kanu cited the Supreme Court's decision in Afolabi versus the governor of Oyo State, where the court held, when an enabling law is repealed, any right, privilege, or proceeding founded upon it automatically collapses. It cannot be saved by judicial contrivance or implication. Nnamdi Kanu is very intelligent. He brought out another citing of a Supreme Court ruling that says that whenever an enabling law is repealed, whenever a law is being cancelled or probably amended, it is no longer in existence, that any rights, privilege, or proceedings found upon it automatically collapses. So Nnamdi Kanu said, look at what the Supreme Court said in this particular case, that whenever a law is repealed, any trial that is made upon that particular law automatically collapses. The Justice James Omotosho and others in court today, we are shocked because they were, are shocked that Nnamdi Kanu had this kind of deep and in-depth legal and sound knowledge of what's actually going on. Nnamdi Kanu, went further and read the section of the section 36 of the 1999 Constitution as amended, Nnamdi Kanu argued in his argument, he brought out the Constitution and read it out for them. Nnamdi Kanu said, and he quoted from the Constitution, "A person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore prescribed in a written law." Nnamdi Kanu brought out the Constitution and read it out, Section 36, that a person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore prescribed in a written law. Now, the charge or whatever the offense is not being written in the 2022 Terrorism Prevention Act. And again, what is even the punishment? The penalty is not even defined. So even if you end up convicting him, on what grounds are you convicting him, and what penalty did the law said or say you should give to this particular person, since you don't even know the law or the charges or the law that you're actually charging him under? Nnamdi Kanu, shocked them. He went further and fired down again. He said he submitted that a repealed statute is no longer a written law, and therefore any charge predicated on it is constitutional nullity. It means if there is no constitutional law or probably that you can charge me under, that means every other thing he has done is null and void. He went further to fire down on this particular case. Nnamdi Kanu fired down and said that once a statute creating an offense is repealed, that the jurisdiction of that particular trial court ceases immediately, that a court of law cannot breathe life into a statute that has ceased to exist. He said that the court will lack jurisdiction immediately. The law that they are using or probably basing to judge someone is repealed or probably cancelled. That means the court automatically lacks jurisdiction and collapses immediately. Nnamdi Kanu did not even stop there. He went ahead. He argued that by proceeding under repealed statutes, that the court would effectively be enforcing a non-existent law, contrary to both the Constitution and judicial authority. Now let's go ahead. Nnamdi Kanu brought to the notice of the court how they disobeyed the Supreme Court's directive. Now pay attention to understand what is actually going on here. He said Nnamdi Kanu drew the attention of the court to the binding directive of the Supreme Court in its judgment on 15 December 2023 in Federal Government versus Nnamdi Kanu, when the Supreme Court gave a judgment on Nnamdi Kanu's case, where it held that only potentially triable allegation, formerly count 15, fell under the Customs and Excise Management Act, not the repealed terrorism prevention or provisions. He accused the trial court of refusing to realign the charge under SEMA, being this Customs and Excise Management, as directed, thereby violating stare decisis and judicial hierarchy. That even when the Supreme Court, let me explain that even when the Supreme Court told emphatically the federal government that this particular count charge, especially the count charge 15, which they brought before, fell under this particular SEMA and not repealed terrorism provisions, that the federal government has refused, as a matter of fact, to even realign or even amend that particular charge, and thereby violating stare decisis and judicial hierarchy. That means they violated something, and for that reason, that particular count charge of terrorism and co should not even be brought to court again, because the federal government has refused to actually amend and probably obey what the Supreme Court equally said. Nnamdi Kanu went ahead to say that the Supreme Court equally erred. That is, the Supreme Court made a mistake while giving a judgment in that particular same 2023. He said Nnamdi Kanu pointed out that even the Supreme Court itself may have erred by incurring when he described the repealed Terrorism Prevention Act of 2013 as extant in its 2023 judgment. By then, the Terrorism Prevention Act of 2013 had been repealed by the Terrorism Prevention Act of 2022. Nnamdi Kanu is even correcting the Supreme Court that when they gave that judgment claiming that the Terrorism Prevention Act of 2013 is extant, meaning it can be used for Nnamdi Kanu's case, that law or that particular act has been abolished or probably repealed, because they gave a judgment in 2023. Meanwhile, it has been repealed in 2022. So Nnamdi Kanu is saying that he's going to talk to the Supreme Court. He went ahead and said that he revealed that he has taken the legal steps to bring this error to the Supreme Court's awareness, hence refrain from elaborating further in open court. It doesn't really speak on the judgment that is being given by the Supreme Court. So he said he's going to meet the Supreme Court to explain to them that this could be a possible error. And James Omotosho and the federal government, they were so shocked today that Nnamdi Kanu came fully prepared, honestly speaking with you guys. Nnamdi Kanu fired down again and told James Omotosho something, that he alleged bias and perception of partiality. He told James Omotosho, look at that Kanu expressed deep concern that the court's repeated refusal to address jurisdiction on the Apex Court directive could create an appearance of bias. He told James Omotosho that since you are refusing to address the jurisdiction, that you don't have jurisdiction over this particular case. That means it seems you are biased and all that. That it creates the perception that this court is not neutral, that it is more concerned with sustaining the prosecution's narrative than upholding the law. He added, with evident restraint, that justice must not only be done but must be seen to be done. Now, James Omotosho, when Nnamdi Kanu said he was biased, Omotosho now asked Nnamdi Kanu if he as a judge has done something to make Kanu suspect his impartiality. Then Kanu said, not yet. I love how Nnamdi Kanu responds to cases. When Omotosho, said, am I being partial or not? Nnamdi Kanu said, not yet. Not like you're not being, but not yet, because a time will come when he's going to tell him the truth, because you are forcing someone to enter a case where you yourself, being a judge, do not have jurisdiction to even entertain or probably even preside. So Nnamdi Kanu now concluded and said something. Mazi Nnamdi Kanu concluded that no valid substituting or cognizable charge exists before the court, and told Justice James Omotosho that even if I don't enter any defense, my lord, you cannot convict me, because you can't convict someone without a written law as per the non-derogable, which is section 36 of the Constitution of Nigeria. So, my lord, our efforts here are wasted, he urged Justice James Omotosho. He ended. He told him that you cannot convict me, because on what grounds are you going to convict someone where the law is not written on inside the Constitution? So James Omotosho was marveled today, and he had to, immediately shift this particular case to 7th, and out of shame said Nnamdi Kanu should do and make sure that he defends his case on before 7th of this particular month. Well, we'll see as things will unfold. Like I said, this is a comprehensive and a full transcript of what actually transpired in court today. See you guys later. Do well to subscribe and drop your comments in the comment section.